Start. Through the public health crisis created by the COVID-19 pandemic, we are witness to another massive tragedy of workers being abandoned by their employers and above all by the state. Stop. The workers' right to go home was carved using the Disaster Management Act 2005. Stop. No provisions were made for their food, shelter, or medical relief. Stop. Wage payments were not ensured, and the state's cash and food relief did not cover most workers. Stop. Para. Staring at starvation, lakhs of workers started walking back home. Stop. Many died on the way. Stop. More than a month later, the center issued cryptic orders permitting their return to their home states. Stop. Immediately, employer organizations lobbied to prevent the workers from leaving. Stop. Governments responded by delaying travel facilities for the workers to ensure uninterrupted supply of labor for employers. Stop. Para. Employers now want labor laws to be relaxed. Stop. The Uttar Pradesh government has issued an ordinance keeping in abeyance almost all labor statutes, including laws on maternity benefits and gratuity. The Factories Act 1948, the Minimum Wages Act 1948, the Industrial Establishments within bracket Standing Orders Act 1946, and the Trade Union Act 1926. Stop. Several states have exempted industries from complying with various provisions of laws. Stop. The Confederation of Indian Industry has suggested 12-hour work shifts and that governments issue directions to make workers join duty, failing which the workers would face penal actions. Stop. Para. Thus, after an organized abandonment of the unorganized workforce, the employers want the state to reintroduce laissez-faire and a system of indenture for the organized workforce too. Stop. This will take away the protection conferred on organized labor by Parliament. Stop. Para. The move is reminiscent of the barbaric system of indentured labor introduced through the Bengal Regulations Roman 7, 1819 for the British planters in Assam tea estates. Stop. Workers had to work under a 5-year contract and desertion was made punishable. Stop. Later, the Transport of Native Labourers Act 1863 was passed in Bengal, which strengthened control of the employers and even enabled them to detain labourers in the district of employment and imprison them for 6 months. Stop. Bengal Act Roman 6 of 1865 was later passed to deploy special immigration police to prevent labourers from leaving and return them to the plantation after detention. Stop. What we are witnessing today bears a horrifying resemblance to what happened over 150 years ago in British India. Stop. Para. Factory workers too faced severe exploitation and were made to work 16-hour days for a pittance. Stop. Their protests led to the Factories Act of 1911, which introduced 12-hour work shifts. Stop. Yet, the low wages, arbitrary wage cuts, and other harsh conditions forced workers into, within single quote, debt slavery. Stop. Para. The labor laws in India have emerged out of workers' struggles, which were very much part of the freedom movement against oppressive colonial industrialists. Stop. Since the 1920s, There were a series of strikes and agitations for better working conditions. Stop. Several trade unionists were arrested under the Defense of India rules. Stop para. The workers' demands were supported by our political leaders. Stop. Britain was forced to appoint the Royal Commission on Labour, which gave a report in 1935. Stop. The Government of India Act 1935 enabled greater representation of Indians in lawmaking. Stop. This resulted in reforms which are forerunners to the present labor enactments. Stop. The indentured plantation labor saw relief in the form of the Plantations Labor Act 1951. Stop para. By a democratic legislative process, Parliament stepped in to protect labor. Stop. The Factories Act lays down 8-hour work shifts with overtime wages, weekly offs, leave with wages, and measures for health, hygiene, and safety. Stop. The Industrial Disputes Act provides for workers' participation to resolve wage and other disputes through negotiations so that strikes/lockouts, unjust retrenchments, and dismissals are avoided. Stop. The Minimum Wages Act ensures wages below which it is not possible to subsist. Stop. These enactments further the directive principles of state policy and protect the right to life and the right against exploitation under Articles 21 and 23. Stop. Trade unions have played critical roles in transforming the life of a worker from that of servitude to one of dignity. Stop. In the scheme of socio-economic justice, the labor unions cannot be dispensed with. Stop para. The Supreme Court in Glaxo Laboratories versus the presiding officer, labor within bracket 1983, said this about the Industrial Employment within bracket Standing Orders bracket close Act 1946 colon within quote. In the days of laissez-faire, when industrial relations was governed by the harsh-weighted law of hire and fire, the management was the supreme master, the relationship being referable to a contract between unequals. Stop. The developing notions of social justice and the expanding horizon of socio-economic justice necessitated statutory protection to the unequal partner in the industry, namely those who invest blood and flesh against those who bring in capital. Stop. The movement was from status to contract, the contract being not left to be negotiated by two unequal persons but statutorily imposed. Quotation close. Stop. Para. Any move to undo these laws will push the workers a century backwards. Stop. Considering the underlying constitutional goals of these laws, Parliament did not delegate to the executive any blanket powers of exemption. Stop. Section 5 of the Factories Act empowers the state governments to exempt only in case of a within quote public emergency quotation close, which is explained as a within quote grave emergency whereby the security of India or any part of the territory thereof is threatened, whether by war or external aggression or internal disturbance. Quotation close. Stop. There is no such threat to the security of India now. Stop. Hours of work or holidays cannot be exempted even for public institutions. Stop. Section 36 capital B of the Industrial Disputes Act enables exemption for a government industry only if provisions exist for investigations and settlements. Stop.